Stephen Butter, a practicing attorney in South Florida specializing in family law litigation. At this time, Florida law does not recognize same-sex marriages. However, there are several aspects of Florida law that can help same-sex couples. We do represent litigants involved in complex guardianship proceedings, sensitive domestic violence issues, adoptions by gay couples, and partnership agreements. All those issues can be resolved under the present Florida law. Like any couple, same-sex couples do not envision getting divorced, but let's assume they get married in a state that recognizes same-sex marriages. After marriage, they move to Florida. They might have lived here 4 or 5 years, and then they decide to dissolve that relationship or get a divorce. Can they get a divorce in Florida? No. The Florida statutes prohibit the court from entering a final judgment of divorce to same-sex marriages because we don't recognize same-sex marriages as a legal union. What does that mean to the couple who married in Massachusetts, for example? Does it mean that they have to go back to Massachusetts to get a divorce? What is the residency requirement? For example, in Florida, you've got to live here for 6 months before you can get a divorce. But this same-sex marriage couple cannot use the Florida courts to get a divorce. So therefore, they would have to travel back to Massachusetts, stay there for the residence requirement, and get their divorce in Massachusetts. But what can we do for them in Florida, considering the status of the current law? What we can do is to negotiate a resolution and a division of the relationship and the assets and liabilities. How do we do that? We do that by negotiating a resolution of all the issues between the two of you. We prepare a settlement agreement, several drafts of that agreement. What are the rights of a gay or lesbian couple in Florida who are not legally married and cannot be legally married in the state of Florida, but can they adopt a child? The answer is yes. What happens if that relationship is breaking up and dissolving? What about the child? Can either one of those litigants petition for custody of the child? The answer is yes. As a matter of fact, the custody section in a divorce case, 61.13, provides the factors that the court will consider in custody disputes. Makes no reference to mother or father, only refers to the litigants as parties to the litigation, or a petitioner and respondent. So you can use the custody statute with reference to deciding who is going to be the custodial parent, who's going to get visitation rights. But on that subject, Florida law has made a big advance. We no longer have the word custody or visitation. We have shared parental responsibility and a parenting plan. In my 50 years of preparing settlement agreements and litigating family law issues, it is always better to settle the issue rather than litigating those issues. And the drafting of that final settlement agreement is critical. The language used, the language that is not used, are critical to a successful resolution. My cell phone, my personal cell phone, is 305-333-7159. Let me tell you that again. 305-333-7159. You can call me at any time. And when I mean any time, I mean Saturdays, Sundays, midnight, 3 o'clock in the morning, because that's when relationships dissolve. Or visit me on the web at attorneystephenbutter.com. If you are in a same-sex marriage or a same-sex relationship and it has come time to end it, remember, you have legal rights. Call me now.